Anpal sir.
Am I audible to all of you, right, sir?
Yes, ma'am. Yes, ma'am. You are audible.
Yeah.
No problem. John sir.
Sir.
Principal, I joined.
Oh, sir, shuru kare?
Yeah, no problem.
Yes, yes, please go ahead.
Okay, sir. Madam, shuru करूया?
हो करूयात, काही प्रॉब्लेम नाही.
Okay. Good morning to all the participants, teachers, and my dear students. First of all, I am Dr. Hemant Sawan. Would like to welcome you all for one-day workshop on intellectual property rights, organized by Ppt College, Devuru, in association with Intellectual Property Department of India under National Intellectual Property Awareness Mission. As we all are aware that intellectual property is a category of property that includes intangible creation of human intellect, such as artistic, literary, technical, or scientific creations. The most well-known type of intellectual property are copyrights, patents, trademarks, and trade secrets. They are the first to the legal rights to be given to the investors or creators to protect his or her innovation or creation for a certain period of time, so that they drive certain financial benefits out of it. So keeping in a view the significance of IPRs, Government of India now emphasizing more and more its awareness among different sections of society, communities, academicians, and students, etc. So hence, we have planned this workshop for our students and faculty members to the great heights. It is an injustice to proceed to the event without calling upon our wings of flight, our pillar of strength, and our constant source of motivation. We cordially invite our Honorable Principal, Dr. Narendra Tendulkar sir, to give their opening remarks.
Good morning. Am I audible?
Yes, sir.
Yes, yes. Very good morning,
Yes,
Madam Deepamala. I am
Yes,
the
sir.
resource person for today's intellectual property right workshop. My professor colleague, Dr. Hemant Sawan, Dr. Sangpal, and student participant, I extend very, very warm welcome to all of you. And at the outset, I expressed my best wishes for this particular workshop. I take a privilege to introduce a little bit about our college. Madam, this college is an autonomous college. And this is the first and only college in Konkan belt that comprises of almost 4 districts that opted for autonomy. And if you see the criteria for autonomous college and non-autonomous college with regard to actually research is concerned. For autonomous college, I mean research, we need to take care of with utmost priority. And normally for non-autonomous college, little less weightage towards research. I just said because this, I mean, intellectual property right, that is not just limited to the research only. But normally whenever we talk about research, then mainly intellectual property right that one has to make mention very promptly. Fortunately, we have designed a syllabus in such a way that particularly for the master's program, I believe in one paper, even there is some curriculum that with that regard to intellectual property rights. I mean, what are the rights and even the legal framework as such. So I believe Madam will touch touch upon all those points in the academic point of view, legal point of view, etc., etc. So without taking much of your time, I would request Madam to, to go ahead. And once again, on behalf of college and Devruk Shikshan Prasarak Mandal, I express my sincere thanks to Madam Deepamala. Sir, please go ahead.
Yes, sir. Before I invite our today's resource person, Srimati Deepmala Madam, to deliver her talk, I would like to introduce her to you all. Madam is working as a senior examiner of trademarks and geographical indicators at Trademark Registry Mumbai. Madam is in charge of the Madrid system and conducting show cause hearing related to trademarks. So with this brief introduction, now I request Deepmala Madam to deliver her talk. Please, Madam.
Yeah. Am I audible to all of you?
Yes, ma'am. Yes.
Yeah. So very good afternoon to Narendra Tendulkar sir, then Sagar Sanpal sir, and students and participants of the today's seminar. And I thank the college and NIPAM for giving me the opportunity to guide the students for their curricular activities in future, what it will be that their future prospectus that I would be guiding, and I will try to explain design, particularly as Narendra sir has said that they have a topic regarding the design, so I will touch upon that also, and with that I will be touching all the IPR categories according to that process, then filings, definitions, and remedies what are available, that I will be touching today's seminar. And I will start with my webinar now. So first of all, we will say that what it will be intellectual property. So we can say that intellectual property is all about human creativity and innovations. Then intellectual property rights are considered as a reward for a creation and skillful works in execution of an ideas. In fact, it is more than a reward for conceiving and executing ideas. In the sense of intellectual property rights are rewards provided as a recognition to the creative work of that person or association, it would be, we can say. So these rights are an incentive for creators and inventors for conceiving and executing innovative thoughts over their that ideas. And we can say that in this business world, one of the processing intellectual property rights will have a definite advantage over other competitors. In this era of globalization, when the entire world is considered as a single or global market, they are notified as stiffer competition we are able to see from all the concerns of the world in any given field. So at this juncture, possession of intellectual property rights would facilitate the owner that better edge in their business. So intellectual property rights are more important for their better business prospects. So again, intellectual property rights exist in different works involving intellectual or mental labor. It will be, generally speaking, we can say that any intellectual effort having commercial value could be given protection. So intellectual efforts in the field of literacy, artistic, or engineering, technological, or science, manufacturing, business, architect, agricultural, etc., gives rise to certain intellectual properties rights. So depending upon the nature of your intellectual property work and field of the application, intellectual property rights have classified into different kinds, we can say, and that can be categorized as a patentable subject matter and the offered protection under the patent system. Then intellectual property efforts in the field of, if suppose it is related to the literature, music, then copyright, then protection, therefore that the intellectual property will fall under the category of the copyright protection system. Then intellectual property efforts in different fields have been offered protection under different set like copyright, trademarks, geographical indication, industrial designs, we can say, then patents, semiconductor chips and integrated circuits and trade secrets we can see. And again, we can say that intellectual property we all know about from beginning itself, but the awareness program is not there, or people are not aware of that intellectual property, because from morning to evening we are touched into the intellectual property rights. Means if suppose we are waking up and if we take paste or brush, that is also intellectual property, that shape of a brush, then a brand of the Colgate or Colgate we can say, that is also intellectual property. Then water what we are using, then purifiers, AquaGuard it will be, or Swatch, Tata Swatch. So these are the various type of trademarks. Then any patentable works will be there, where we are using in our day-to-day life from morning to evening. So we know about the intellectual property in our daily life. So I will take you brief through the category wise, the intellectual property, what it is, how it will be giving protection to the holder or owner of the that property holder. So I will take you through you the PPT presentation. I would like to present my PPT now. So are you able to see my screen?
Yes, ma'am.
Yeah. So now I can say that this is the intellectual property which is categorized under that patents, trademarks, then design, geographical indication, copyright, semiconductor, integrated circuits, layout designs. So these topics I will be covering in my PPT today. So first of all, I would like to say that different IPs in a single product. So here you are able to see that Apple laptop is there. So in each part we can say that this is the intellectual, just a minute, somewhere I missed it. Yeah, so here we can see that LED displays we can say as a patent one. So Apple is visible, that can be a trademark. Then user manual you are able to see that layout design, it will be protected for intellectual property. Then body of your design of that laptop will be covered for a designs. So we can say in one, first of all I have started with that what it will be the intellectual property. It will be nothing but it is a creativity of or intellectuality of that person, so will be related to brain. Then resources means for making of that product, what resources are available for me, means in the sense we can say that raw material or any funds or something like that. Then labor, for creation of that particular property I need a labor effort. So including all these my intellectual property will be creating. So these are the important ingredients of any intellectual property. So importance and significance of the any intellectual property means what? That will be protecting the rights of a particular proprietor or author of that intellectual property, and that can be restricting the others from using their brand or their trademark or their particular product. And again, it will be giving benefit to the owner of the property, that utilization and commercialize that property and earn profit from that property. So these we can say that after registration, that importance and significance of the intellectual property. So first of all, I would like to take you for the patents. So what is mean by a patent? So we can say that patent is a grant of sovereign or state to a person, giving exclusive right to stop others from making, using, exercising, vending and importing. So in this we can say that earlier slides also I said that after getting a protection from the authority that certification if you are getting, so it will be given an exclusive right to the owner to use his property or vending or exercising rights or for commercialization purpose. That person is getting rights and he is able to get the benefits from his property after commercializations. Then invention for a limited time period it would be. Then in exchange for disclosing it in a patent specifications such that anyone having average skill in that art can reproduce the invention. So these rights will be a limited period time will be given by the authority, and patent will be given for the 20 years time period. So here we are able to see that famous inventors and inventions. So first of all, I would like to say that this first patent, which was taken by the Alfred Depending in 1856 for a efficient pankha, where that image is visible in this place. And he was a civil engineer and he invented this invention, that efficient pankha pulling machine. So he was able to show that how it is a distinctive or how it is innovative, novel to the industry, and he has taken that grant of exclusive privileges for his invention first time, and in 1856. And this is the patent was first granted, and this is first, which is oldest one innovations. And again, we are able to see that down to that some of the examples are there and their inventions are there mentioned. So Thomas Alva Edison, who has invented that phonogram, which is we can say as a record player. Then Alexander Graham Bell, who has invented a telephone. Then Wright's brother has invented aeroplane. Then Louis Pasteur has been invented a rabies vaccination. Then Alexander Fleming, who has invented that penicillin. So these are the scientists and their inventions, famous inventions, we can say. And famous Indian inventions, if we talk about, then now in our that day-to-day transactions, we are using nano car, then hepatitis vaccine. Then here we can see that here we can see that Jaipur food affordable prosthesis that we for used by the handicapped person. So these are our famous Indian inventions. Again, we are able to see here that maybe that shower cap is there, then wristwatch is there, from where we are able to access our mobile or any device after putting this on our wrist. Then we can see here that card reader also is there. Then drone also is there visible. Some functions of that cameras and recording of that will be done through this drone system. So these are the examples for the patents we can say, and these can be considered as inventions. So again, I will take you through that designs. So designs, we can say that ornamental or article, features of shape or configuration, then pattern, ornament or composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional, or in both forms, we can say, by any industrial process or means, whether manual, mechanical or chemical, separate or combined, which is in the finished article appeal to and are judged by solely by and I. So here we can say that this will be, we can see that interior designers will be there. So they will be that dress designers also will be there. So here we can see that sari designing also covered by the Designs Act. Then pankha that or fan, ceiling fan, we can see that here design has been made. So this also can be a design protection, comes from the design protection. This purse also, hand clutch, which will be used by the women at parties or in daily transactions for keeping their valuables. So these also we can say as a designs, which can be a eye-catchy, or we can say that it's a unique design. So that also can be covered for the design protection. So here we are able to see again a portable washing machine design has been made which is unique, so that also can be considered for a design protection. So mainly design protection will be given for 10 years and it will be further extendable for 5 years. So total design term for the protection will be given 15 years, not more than that. So again, here we are able to see that shape, configuration and surface pattern of the bottle. So here you are able to see that different bottle shapes, then that embossing of the design of on the bottle, it is visible. These are the patterns of bottle we can say, and that also can be considered for the design protection. So here we can see that design of an article, what it would be. Then here we are able to see that car designing, it's there, table lamp designing is there, alarm clock designing is there, then cloth design also is there, then inhaler designs also is there. So these can be a designs of an article we may see. Then again it will be coming that set of articles means what, which will be sold together, we can say any set of articles in the sense. Here you are able to see the example that necklace is there with the common design which is mentioned that in earrings, then that necklace also, and that bindi also, it is visible that same designing has been incorporated for that set, which will be completed set, we can say, for that set of design articles. Then again sofa set you are able to see here, which will be same designing and it is a set of the same. Then shoes also we can say same designing it is, and it is also called as a set of designs of articles. Then here we are able to see that cup saucer with a tea set. So this also it will be called as a design of set of articles. So here we are able to see that how it will be the filing of design applications. So mainly that all related to that physical filing will be done in IPO Delhi, Mumbai and Chennai and Calcutta. And digitization will be done through every branches, but examination, registration and publication of and post registration related, that application related, whatever process will be done, that will be main office will be IPO Calcutta. So main proceedings or whatever things will related to the application for examination, registration, publication and post registration will be done through the IPO Calcutta. And only physical filing or receiving of application we can say Delhi, Mumbai and Chennai offices. And even Calcutta also will take the physical filing of that applications. So main branch will be for designs will be located at Kolkata. Then here we are able to see the requirements to file an ordinary application. So main application fee will be there for any person, individual, smart entity, startup, and that will be for 4,000, and for individual it will be 1,000 and others for the 4,000. Then application form 1 you have to fill up. Then what will be the content of the application? So here we are able to see that applicant's full name should be mentioned, the nationality, legal status in the sense, if suppose your body in corporate company is there, so and it is registered with the registration of companies act or office or register of companies that it is registered with that, or any partnership form is there and it is registered that as per the provisions of the act, then that legal status you have to mention in your application. Then address for service in India. Then classification we have given particular, that product wise we have a classification which is available in our official website ipindia.nic.in. So there you are able to see that designs classification is available, and as per your product or article you have to choose your class and the name of the article. So earlier example we have seen that sari designing was there, then other that fan designing was there, cloth designing was there. So in according to that you have to mention your name of the article, and if suppose priority data if it need, that you have to mention. Then prior registration data, if suppose you have already registered data or application with designs, then you have to mention that also. And then applicant signature and date you have to mention at the end of the application, and that will be given in 2 sets of representation. illustrating that various views of your article. In the sense, we can say that front view, back view, then up view, down view, that various views you have to mention in your application. Then if you are coming with that attorney, then you have to file a form 21, and that power of attorney copy you have to attach. If suppose any assignment document, if it is there, then assignment document you have to mention. And if suppose you have that small entity or startup, then you have to file a form 24 for stating that you are a startup business to the registry. So here we can see the specimen copy of a representation sheet. So here we are able to see that teapot. So here they have given the views of the teapot, and here we can see that that novelty shape configuration for the teapot as illustrated. So if anything related to the registration, earlier registration, if it is there, that you have to mention. If any claim, if it is there, you have to mention here, and signature of the applicant and agent name and signatory and date. So this will be the representation sheet of the specimen which I am showing here. And once your patent design is getting registered, then patent office will issue a certificate of registration. So in this we are able to see that design number means your application number, which is given after receipt of your application to the registry. We will generate one number, identification number we can say, or reference number we can say. So that will be called as a design number. Then date when you have filed your application. Then other things, if suppose your priority dates are there that you have mentioned in your application, that accordingly will be incorporated in registration certificate of designs. Then here you are able to see that that name of the applicant, address, it visible, and down to that controller general of the patent designs and trademark signature is there. And this will be a that registration certificate will be issued to the particular person after getting it registered. So publication of any particular design, how it would be. So this will be a sample I am showing you. So here we are able to see that chest compression device for a first aid. So these views will be given by the applicant. So he is mentioning his design, what it is, and he has given the title of his design, then date of registration, and then class, what it was according to his product. He has mentioned his class as a 2404. Then design number means it is application number, the name of the proprietor and address of the that proprietor has been given, and this will be published in our journal. And means after getting all objections waived off by the registrar of designs, then application will go further for the publication in our journal, and this will be the preview or a sample of your publication product. After that, we can see that trademarks. What is mean by the trademarks? We can say that trademark means any word, name, symbol, or device, or any combination thereof. So which identifies and distinguishes the sources of goods or services from one trader from those of others. So what will be the functions and importance of a trademark? We can say that provides exclusive monopoly over the class of goods or services. In the sense, if suppose I have filed a trademark for clothing purposes for class 25 in the name of Deepmala itself. So if once my trademark is getting registered, so I have a monopoly over the clothing for class 25 for the word trademark, that trademark Deepmala. So nobody can use the name of me or trademark which is already registered with the trademark registry under the name that Deepmala for a particular class 25 for the goods clothing. But if suppose some other person is applying for a Deepmala for 25 only, but he is coming for the footwear, so he has right to get the registration as my category of consumer or category of business, we can say it totally different from each other, because clothing person and footwear persons are totally different from each other. So my rights will not be getting hampered by the registration of the any Deepmala other trademark under for that class 25 for footwear. So here I cannot say that it is similar to my trademark or like that. So provides exclusive monopoly over a class of goods or services, allows a business entity to build public goodwill and brand reputation. If suppose my name is registered or Deepmala is trademark is registered with trademark registry, and if suppose I have a clothing related product, so particularly if suppose I'm giving that cotton or cotton clothing, so if suppose that is has that brand what I am preparing or I am manufacturing, so that brand or quality I'm trying to maintain. And so in that brand reputation will be created, and after use of that particular product, people will get that, yeah, if suppose we are using the Deepmala's cotton saris or kurtis, that color will not fade or cloth will not shrink. So that particular quality has been given by that particular manufacturer. So that automatically generates a goodwill in the minds of public, and my mark will create that brand reputation. So we can say that now Cotton King, we can say that it is a brand reputation and goodwill. Then again, Peter England for cotton shirts, we can say these are that goodwills already created in the mind of public, and brand reputation has been created in the public. So this will be calling like that, allows a business entity to build a public goodwill and brand reputations. So identifies the source, origin of goods and services. So here we can say that if suppose identifies the source, means from where it came, or from that for what goods and services it came. If suppose I'm giving, and my particular area is suppose like Dadar, I'm manufacturer for that particular product. So that can be assured that on my product itself or packaging of that, this product will be identified by this address, and this is the symbol for that Deepmala product for cotton saris or kurtis. So that will be identified by the packaging itself. So it will be helping for the people to identify a particular product. If suppose somebody trying to that dilute my trademark, so that people are able to get what it is exactly, means original ones which one and duplicate one which one. So that will be the particular identification will be given. Then assures customers about quality of goods and services. So earlier I have said that if suppose I'm giving a particular cotton, and people are saying that no, after wash also it color it's not going, or that cloth is not shrinking. So this is the quality given my product. So this assures customers, yeah, if we are using the Deepmala's product, so that has a particular quality in that product. So this is the assurance after that getting trademark registration, or I will be trying to give a more quality to the public. So here we are able to see that some of the examples of the trademarks we can say. So here we are able to say that Coca-Cola bottle is there, Coca-Cola trademark which is written on that. So it will be an industrial design also we can say, because it is a exclusive shape of a bottle, it is there. Then M, after seeing M, you might be getting that yeah, it is a burgers or McDonald's burger or McDonald's related products. Then this curve, if you are seeing the Nike, you are able to get. Then Adidas for shoes, we can say. Then Google for search engine, it will be Naukri.com for that Naukri related or job related or career opportunities will be there. Ye Dil Mange More for Pepsi, we can see that slogan, it is there, or tagline we can say. Then here we are able to see that BIS hallmark register, that mark is there, which will be given for a particular the quality or purity of a gold we can see say. So that will be a certification for your particular product. So that will be called as a certification marks. And collective marks means what? That collective mark is a trademark owned by an organizations. So that association or organization, we can say that for particular identification of their quality or accuracy of their that services will be given, that we can say that CA's that Chartered Accountant Institute will be there, or company secretaries institutions will be there, that will be covered for the collective marks. Then what will be a good trademark? So we can see here that distinctiveness, inherent distinctiveness, acquired distinctiveness. Inherent distinctiveness will be like we can say that some of the marks we are able to coin the words, like Kodak we can say, then Canon for printers we can say. So this we can say as an inherently distinctive the trademarks. And acquired distinctiveness, we can say that Bisleri or AquaGuard. In nature it is not distinctive, but they are become acquired by use in the that public means that mark after getting used or popular in the minds of public, then that mark we can say as a by use, that acquired distinctiveness has been earned by that trademark. Then that whenever you are filing for a trademark application, so deceptively similar, and then where you will be get that deceptively similarity before filing the application. So in our website we have given a one public search where you are able to get that trademark, where you are able to get our register also. So if suppose you want to file the mark for any trademark and for particular class or goods or services, then you have to put your trademark, then class you have to choose, and you have to put the search. So related to your trademark, some of the marks or will be already registered with our registry, that record you are able to say get. So you have to cross verify with our already registered or pending trademarks, which is already mentioned in our register. So accordingly you have to come with some changes in your trademark and with changes in your goods and services, so that it will not be hurdle for your trademark to get it registered, or instead of getting that refusal you will not getting. So before filing you have to do the public search, and then only you have to come for the trademark filing. Then how it will be indicate your trademark? Once your trademark is filed and it is pending with the registry, so you are able to use this TM on your trademark. Means it is giving intimation to the public that you should not file the same trademark, because I have already filed this trademark and it is pending to the registry or authority. So that person is having the knowledge, okay, I cannot use this trademark. And when your mark is getting registered, then you are having authority to use the R in the circle. So you may say that people is getting intimated, yeah, I should not use this mark because this mark is already registered with the authority. And if suppose I am using this one, then that proprietor of that particular sue for the infringement of his trademark against me. So you should not use the particular trademark for as a brand name of your particular services or goods. Optional one, it is not compulsory. We have to understand for itself. Without registration also you are able to use your trademark, but for rights or any remedy if you want to claim for that purpose, and for brand goodwill creation of your trademark in the minds of public, you have to register your trademark. So that given that certain advantages to the proprietor or holder of the trademark. So registration available at national and regional or international level. So international level, if you want to protect your mark, you have a now Madrid system, which is acceded by the India on 8th July 2013. And on that basis, you are able to file your application, and you are able to get your mark globally. Initially registration will be for 10 years, and can it be further renewed indefinitely? Means here the trademark owner has a perpetual rights after renewal of the his trademark, so it will not be going to end for that rights of that particular product, so it will be perpetually given to the particular proprietor of the trademark. So in case non-use or non-renewal or no policing trademark, rights are lost. If suppose you are not using the mark from the date of registration within 5 years, or that will be getting cancelled, then if suppose after 10 years you are not renewing your mark by paying your fees, or if you are not able to do that one, that policy which has been taken by the trademarks, that given by the trademarks provisions, so your rights which was given earlier after registration, that will be lost or removed. Then existing trademarks that will be governed by the Trademarks Act 1999 and the Trademarks Rule 2017. So whatever will be related to the examination, registration, or withdrawal of acceptance, or any opposition proceedings will be governed by these two provisions of this means Act rules of this particular year. We will be applicable, that provisions will be applicable to the proceedings, any proceeding, trademark proceedings. And if suppose you want more information about the trademarks, so manuals are available, how we are working, what will be the sections mentioned in Trademarks Act 1999, what will be the rules mentioned in 2017. So Trademark Act rules and our manual, office manual, how we are working, that will be that is available on our ipindia.goi.in. So you can visit and you may download the PDFs and you may study further for the trademarks. Then we can come after that copyrights. So what will be the copyrights? That we can say that copyrights is like literary or artistic work, or any dramatic work, or any cinematographic work will be there, or films will be there, that will we can cover for the copyright protection. And that definition of a particular work has been given in section 2Y of section 13 of Act 1957. So whatever provisions will be applicable for the copyright will be governed by the Copyright Act 1957. So here we can say that Copyright Act gives the after protection of your copyright work, that will be given as a bundle of rights. Automatic rights will be there, exclusive right given to the creator, allows the owner choose the ways or his or her copyrighted work are made available to the public, prevent unauthorized copying or reproductions. So these are the rights. We can say that after protection of a particular work, that owner of that copyright, he will get the rights for particular use of his product or work. So here we can say that copyright cannot protect an idea. So here I can say that if suppose today I want to write any thing about any process, or anything about any institutions, or anything about any book related to any theme I want to write. So some ideas are in my mind, or in my brain it is there, what I should write, or what it should be a content of my particular that or article what I am going to write. So that ideas only cannot be protected. But if suppose I have that graphical representation, means tangible format, I have expressed my ideas about any particular institution, what I want to write, so that can be a part of a copyright, but only idea cannot be a part of a copyright registration. So here we can say that criteria for work to be copyrighted. So fixation will be there. So fixation in the sense we can say that tangible form of expression should be there. So that will be called as a fixation, means mere ideas cannot be copyrighted. So some of the form expression of your tangible medium should be mentioned, then that will be called as a fixation. Originality in the sense that idea should be original, means it should not be earlier published in the market or anywhere in social media or any other outside to India also it should not be published. So that originality is the important for that. Then creativity, we can say that means independent creativity of an author, it should be there. And minimum modicum, we can say that a small quantity or particular thing, especially something desirable or valuable, at least a modicum we can say. So after that, we can come to that subject matter of copyright, what it would be. Then section 2 of Act, it says that literary work. Literary work means that authors writing books, then script writing, or any manual. I said at the beginning of the my PPT that the manual for the laptop will be a copyright. Literary work we can say. Then artistic work, in the sense we can say, see here that example is given that paint has been dancing lady is there and that has been painted. So we can see this is the artistic work. Dramatic work, in the sense on any song, any choreographer has put and some steps, and that can be covered for the dramatic work. Then musical work, we can see here that one musical notations has been mentioned in this image, so that will be a musical work. Then sound recordings means if suppose I'm singing any song and that recordings has been done, and I don't want anybody should take the rights for my sound recordings, so that will be covered for the sound recording works. Then cinematographic films, in the sense we are able to see now movies going on, we are watching daily live movies, Marathi, Hindi, English, Tamil, Telugu, Kannada. So these can be covered for this section, that 2F of the Copyright Act. Then we can see here that copyright has given that author a copyright for his copyright work. So copyright rights can be divided into two parts, we can see, or it can be categorized for two types, that economic rights, which will be covered under section 40, and moral rights, we can say section 57. Sir, could you please mute yourself? So moral rights are mentioned in section 57 of the Act. So economic right, in the sense what we can say that transferable rights means maybe assigned, or maybe that assigned to other owners for sum of money, means in consideration of money, or after assigning my rights I will be getting benefit money or in form of money. That will be called as economic right, means after use of that mark I will be getting benefit from my work. So that will be considered as the economic right. And again, that will be proposed usage of the work will be given by that particular author or a particular person of the copyright work, or a registered holder of that copyright work. He will be deciding how he will be using his economic right. Then moral rights will be there, that we can say that it will not be a transferable rights, that always remain with the original author. So this will be depend on the original proprietor, or we can say that author of the particular work. So after that, we can see that scope of economic rights. So reproduction rights are there. That rights will be preventing others from making copies of your work, right to reproduce work in material form. So this rights has been given by the registry after the registration of the copyright to the particular author. Then distribution rights are there. Then physical copies of work, rights of rental, he can do that one, and he can earn that benefit from his work. Then right to create derivative works, adaptation will be there, translation will be there, compilation will be there. Means if suppose I want to create derivative works, in the sense I will be giving that my original work for translation. So for translation also I will be charging something, or that I will be getting that translate. So we can say that translation, compilation, if suppose my work is getting published, so for that purpose some compilation procedure will be there, some unwanted part will be there. So compilation rights also I will be able to give, and then out of that, what are the things or in the form of money it is coming, that will be called as an economic right. Then cinema, sound recordings will be there. So after publication, I will be getting the economic rights of that particular work. Then right of communication to the public, then relying of the work of distance and interactive communication means. So in that communication, in the sense on social media or any TV channel, that will be also a royalty creating economic rights given to the copyright holder. Right of the public performance. If suppose I want to perform or I want to give my rights of the songs for public performances, and in consideration of that, I will be getting any royalty from that particular person, where I will be giving my rights for the performance for the work in public. Then here we are able to see that term of the protection, which will be mentioned in our Act section 22. So according to the category, there are period has been mentioned for particular product, how much that protection will be given for that particular copyright holder. So published literary or dramatic, artistic, musical work, it will be lifetime of author plus 60 years. Means if suppose publication will 60 years will be counted after the death of the holder of that copyright, death of the holder, that 60 years will be counted further, or life of the author. Then cinematographic films and sound recordings will be given for the 60 years from the date of publication. Broadcast reproduction rights will be given 25 years from the year following the year of broadcast. Then performance right will be given 50 years from the year following the year which performance is made. Then again, we can see here that application procedure. So for copyright protection, you have to file form 14, and every such application can be filled in copyright or filed in the copyright office by person or by post or by e-filing facility also is available. And payment can be made on payment gateway online. You will be getting the details of how you are able to do that online. E-comprehensive system facility has been provided in our website. And if suppose you want to come to the office and you want to pay that one, so you are able to pay to the counter or DD if you are issuing in the register of copyrights, that also payable at Delhi, then that also can be considered. Then here you are able to see that fees of that application, how it will be. If suppose the literary, dramatic, artistic, musical category, if it is there, then 500 rupees will be charged. Then artistic, it will be 2000 rupees. Sound recordings, it will be 2000 rupees. And cinematographic films, it will be 5000 rupees. Then examination procedure, how it will be. So application received at Copyright Office, Delhi, then formality check will be there, and then waiting period and scrutiny will be done by our office. And if suppose there is no any discrepancy or no any objection raised by the registrar of copyright, your application will be approved by the registrar of deputy registrar, that registrar of that particular branch. Then your application will further proceeded for the registration. And if there is any objection has been raised by the examiner or registrar of copyright, then that discrepancy will be sent to the applicant, and then applicant will be giving a response to particular objections raised for this discrepancy later. And if suppose that applicant is failing to give the response, then application automatically get as an abandoned one. And if suppose discrepancy removed, then application will process further for the registration. And if suppose that application that response is not satisfactory, then a hearing chance will be given to the applicant in front of registrar of copyright. And then after hearing that, if suppose hearing officer is satisfied with the submissions made by the applicant or his attorney, then your application will move further for the registration, and you will get the registration certificate of copyright. And if suppose he is not satisfied with your arguments done, then your application will be rejected. So you will not get the registration certificate for the particular work of your copyright. Then after that, we are come here for the semiconductor integrated circuits layout designs. So here we had that semiconductor integrated circuit means a product having transistor and others circuitry elements inseparable formed on an inside out semiconductor or insulating material designated to perform an electric circuitry function. So starting off the slide, I have started with the laptop. So there we have one image that circuitry functions or transistor, we can say that one. So how it will be working, that functioning will be depend on that electronic circuitry function. After fixing it into the laptop, that functions of the laptop will begin. So this will be covered for the semiconductor integrated circuit. Then layout design in the sense that how it will be, means some of the wires or some of the connectors, where it will be getting fixed. So that layout design, we can say that how it will be. So that will be come for a layout design protection. So semiconductor integrated circuit design registry, it's located at Delhi, and where the application of layout design of integrated circuits are filed for registration of created IPR. Then that semiconductor integrated circuit layout design is an important IPR for protection of products with fast changing technologies such as electronic gadgets and computers. So integrated circuits, that electronic gadgets have, every gadgets and computers has integrated circuits in it, which is more important for the protection of your layout design and semiconductor, that the product or IPR, under that IPR for particular this office, you have to file and take your protection from the copy, that same designs office. Then this layout design will be given for 10 years from the date of application, filing, or first commercial exploitation, which is earlier. So that protection for the layout design will be given for 10 years. So here we are able to see that how it will be the process wise of the and fees of the that layout designs product it will be. So here you are able to see that the process, it will be like form LD1 layout design you have to file, and that application will be filed by the particular person to the layout design registry, and then that application will get examined, and that particular, if suppose that register of layout design is getting any objections, so that objections will be communicated to the applicant, and that applicant will be giving the response to that. And then if suppose a registrar is accepting the applications with some modifications, so he will be giving the hearing chances, and if suppose he is not willing to do that modification in the application, so application will be refused. And if suppose registrar may accept or accept with some modifications or issues at hearing, then he will be accepting his application, or he may consider for the publication, and this application will be published or advertised in the journal within 14 days of the acceptance, and no any opposition comes within the 3 months from the date of publication. So if suppose my mark is published for today's date, means 18/2, so from 18/2 we have to calculate 3 months, and in 3 months, if suppose no any opposition comes, then that layout design certificate we are able to get, means our registration for layout design is done. And if suppose any opposition comes, then opposition proceedings will be done, and then output of that opposition proceedings, your application further moved further for the certificate. So after that, we will be coming here that the geographical indication. So now I can show you that geographical indication one video, where you will be able to get that actual what it would be a geographical indication. Are you able to see my screen now?
Yes, ma'am.
Yeah. So here you are able to see that how it would be a geographical indication.
There is no audio, ma'am. Is there any sound to this video, ma'am?
Madam, audio is not clear.
No audio is coming.
Madam, audio is not clear. Please increase the volume.
Hello? Yes, sir.
Audio is not clear, ma'am.
It's there because I am using that Ethernet connection. So network is very proper and I have put it on 100%. So more than that, I cannot increase also.
Yes, but it is not clear.
I don't know what is the problem because I have
It's very
shared
small one.
and
Yes.
Then please try it from your end, that voice. If you are increasing, then you might be getting that louder one.
No, madam. From
Because
our end also it is 100%.
Yes, from my end also it is 100%. So I don't
Okay.
know because
Madam.
earlier also I used to share like this only. So people was able to hear. So I don't know what is the problem then. So whether I have to continue with this?
Not audible, ma'am.
Nothing is audible.
Yes, nothing is audible.
Just a minute, I will call my person to check it out.
Share it again.
Just a minute, I will play it. सर्जिल थोड़ा सा ये ना पटकन just a minute, he is coming, so we will see that. बघ बरं. आता कर बरं. आला ना आता.
रजिस्टर्ड हुई थी.
लेकिन नानी एक बात बताओ, इन जीआईएस से
आला होता आता आवाज?
येस मॅम, इट इज ऑडिबल.
आला होता ना? ठीक आहे.
हो हो, येतोय.
हा, एक मिनिट मी परत रिप्ले करते. येतोय ना आवाज?
हो, येतोय.
हा, ठीक.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर. ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट. अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है. लखनवी चिकनकारी पूरी दुनिया में मशहूर है. ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है. लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है.
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं. ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है. मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ.
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं.
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख. ये एक मधुबनी पेंटिंग है, बिहार की. और ये है हिमाचल की कांगड़ा पेंटिंग. तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है.
अच्छा,
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं. इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं.
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं. हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं.
वाओ नानी।
चल अब तू चाय बनाने में मेरी मदद कर. एक बर्तन में पानी ले और उबालने के लिए रख.
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है. ये देश की सबसे पहली रजिस्टर्ड जीआई है जो रजिस्टर्ड हुई थी.
लेकिन नानी एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं. इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है. उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है. साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं.
ओह, वैसे नानी मुझे एक आइडिया आया है.
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं. क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So this was a video about a geographical indication, and just a minute. So I will be again taking you for my PPT presentation. So here in video you have got that what are the importance, how that rights are important for a particular group of association or particular area. Some products they have given the examples which we are using in our daily life. So here we can see that geographical indication, some of the product has been given, and geographical indication we can say that identifies a product of a particular association that have a specific geographical origin and specific qualities or a reputation that are due to that origin. So here is the first registered GI. We are able to see that Darjeeling tea is there, then Makrana marbles are there, Bubbly Vida is there, then Bastar Dokra also is there, then Venkatgiri saris are there, Nilgiri trees, tea is there, then Nagpur Santra is also there, then Surat Zari craft also is there, then Jirakla rice of Wayanad also it's there, then Madurai Malli also is there. Madurai Malli in this sense, one flower it's registered, means like we can say that Mogra or Jai, like that it is the flower, scented flower. So this is the Madurai Malli, Malli in the sense flower. So then we are here able to see that handloom saris are there. Then again we can see that some of the products that are we can see that Darjeeling teas, then Makrana marbles, then Kanchipuram silk saris are the Pradesh are registered GIs are there. Then some of the handicrafts we can see here that Rajasthani Katputlis are there, then bark prints of Madhya Pradesh are there, then Bengal Patchitra is there, then Warli paintings of Maharashtra is there, Bidriviar of Karnataka is there, then Lychee is there, then Kashmiri saffrons also are the registered GIs. So IP is everywhere. That first starting of my seminar, I have said that from morning to evening we are coming into the contact with the intellectual property, but we don't know why we came into the contact with intellectual property, and we are using in our day-to-day life. So how we are using that in our day-to-day life, that one video I will be sharing. So you will be getting that how IP is around us, or how IP is everywhere in the home or market or outside the home, we can say. So that one video I will be sharing with you now. So are you able to see now?
Yes, ma'am.
And please check the sound. Sound is just coming now. Sound coming now.
Yes, ma'am.
Yeah.
Yes, ma'am.
So here you have seen that how we are coming into the contact with the intellectual property. So after that, we can come for the particular validity of particular category of intellectual property. We can say here that patent will be given for 20 years and there is nothing called a global or international patent. And designs will be given for first time, it will be 10 years and further it is extendable. And rights given to the trademark holder initially for 10 years and it will be after also same indefinitely period of that it will be given to the 10 years and then further it will be extended after receipt of the fee payment of the renewals. And copyright will be depend on the published literary, dramatic, artistic and musical works and it will be for lifetime author or plus 60 years of that publications from that this one product related to category wise. And earlier slide I have said that about the copyright, how it will be that protection of particular category of copyright work. So points to remember for this, we can say that first protect and then publish. So first, whenever you are filing or you are trying to do the business or trying to innovate something, so first get it protected before keeping it into the market. So these will help you to that duplicacy or a dilution of your particular intellectual property product. So that will be helping you. So you have to first protect and then publish your particular innovation or copyright or design or any trademark or geographical indications. That rights are territorial, limited to boundary of country. Sovereign authority will that registration is required in each country. Suppose you want to do that one, then you can do that with particular country or that globally also you are able to protect your trademark or any intellectual property according to your category wise. And registration will be done by the, in India, it will be government of India will be the authority for giving the registration, and rights for a limited period will be given. And no automatic relief. If suppose you are seeing that any infringement for your particular mark has been done, then you have to file a infringement suit against particular person. Then only that relief will be given to that particular proprietor or register holder of that particular GIs. And then for designs, it will be one time renewable for 5 years. And GI and trademark will be perpetual renewation can be done. Then after that, we can see that career opportunities. So people who is wishing to select the IP field for their career as an opportunity, if they are saying, then what will be the opportunities available for a particular IP that field chooser. So we can see here that government jobs are available. So examiner of that particular person can become an examiner of patents and designs, then examiner of trademarks and GI, then examiner of copyrights also is able to become. And for this, we have certain process of that examination will be conducted and followed by the interview it will be. And that will be done through either by the DPIIT or UPSC will be conducting these opportunities. So you have to check the website for that UPSC for advertisement, and DPIIT also will be giving that advertisements for patents and designs. So you have to check the periodically for the advertisements, and that will be a written examination followed by the interview will be conducted by our office. Then other opportunities are there, that patent agent you are able to become if suppose you have science background and law degree holder. That law degree is not compulsory for patent agent, but you are able to, if you have the law degree, that will be additional qualification for that one. So patent agents will be conducted in our office yearly, and that advertisement will be coming before examination 6 months prior. And you will be able to file the application for the patent agent. So if once you are becoming as a patent agent, so you will be getting opportunities for the particular IP firms, like renowned IP firms are Mumbai based. We can see that Krishna Saurashtra is there, Lal and Sethi is there. Then again we can say that RK Diwan is there. Then Nike and Nike is there. So these are the law firms for particularly they are dealing with exclusively for the IPR. So you are able to become that employee for that particular forms after getting the patent agents. Then trademark agent also, that examination will be conducted. So trademark agent will be conducted for the non-graduate of a law background. Means any person who is graduate, he can come for the examination and he can become a trademark agent. So same opportunities are available as of patent agent. So they can file for the any IPR firm for their career opportunities. If somebody is seeking for that, then trademark agent is also available for the persons who are not a graduate, that not having law background and with law backgrounds. Then junior research fellow, senior research fellow in patent facilitation centers are available, and patent litigation and other opportunities in private sectors also available if the person is choosing for the IPR. So here, if suppose you want any further diploma courses or certificate courses for the particular IPR, so you can contact our RGNI PM Rajiv Gandhi National Institute of Intellectual Property, which is located at Nagpur, and you can contact on these phone numbers given below to this, and you otherwise you can mail them for rgnipm.ipo@nic.in, or otherwise you may visit our official website, that is ipindia.gov.in. So you will be getting further that guidance from our institute for or any certification course or training program you want to do. So you are able to enroll yourself. Our that institute is available for exclusively for that purpose only. So now I will give you a one puzzle. So are you able to are mentioned in trademark or brand names of a particular product? If you find out, then please say me what it is. Yes, somebody said Pepsi, right?
Bubble.
Yes.
Amul.
Yes.
Puma.
Sorry?
Lux.
Yes. Here it is Lux. Sorry. Here it is Lux. Pepsi is here. Amul is here. Bubble is here.
Amul.
Yes, Amul. First, somebody said Amul. Yes.
Bata.
Sorry. Ah, yes,
Bata.
Yes, Bata.
Horlicks.
Bata is there. Yes, Horlicks also is there. Horlicks is there. Yes, here.
Cadbury.
Yes, Cadbury also there.
Tata.
Yes, Tata also is there.
Dettol.
Yes,
Dettol.
Dettol also is there. Okay, I think you have guessed all. So I will be showing you the answer of your puzzle. So here Pepsi, Amul, Tata, Dettol is there, Lux is there, Horlicks, then Cadbury, Link, then Bubble, Bata. So these are the famous trademarks we can say, or brand names we can say. So after that, I will take you for questions I will be asking. So anyone can unmute themselves and then answer. Which type of IP protect the paintings patented by the artist? copyright, geographical indication, patent, designs, and trademarks. What will be the correct option for this question?
GI.
No.
Copyright.
Yes, copyright is there. Because this is the artistic work. Artistic work will be covered under the copyright. So painting which is painted by the artist, then artist right will be covered for the copyright. So correct answer for this question is copyright. So what protects in the intellectual property created by the fashion designer? Copyright, geographical indication, patent, designs, trademarks. What will be the correct option for this question?
Design.
Yes, designs. Then what protect the advanced disc brake for bike developed by the inventors? Copyright, geographical indication, patent, designs, trademarks.
Trademarks.
No, this will be a patent because this is an invention. Invention for a disc brake for a bike, and that will be developed by an inventor. So inventions always belong to the patents. Then which of these geographical indication? BMW, Nagpur Orange, ironing machine with stem, PlayStation's World Wide Web.
Nagpur
Yes,
Orange.
Nagpur Orange, yes. What does trademark protect? An invention, art of work, logos, names, and brands, a secret formula.
GI tag.
What it would be? A trademark protecting? Yes, please say me the answer.
Logos, names.
Yes, yes. So an invention will be protected by the patent, a work of art will be protected by copyright, logos, names, and brands will be protected by trademarks, and a secret formula will be protected by a trade secrets. Then how long can a patent last? For 10 years, 20 years, 40 years, 60 years?
60 years.
No, 60 will be for copyrighted works. Yes, patent will be for 10 years, 20 years, and trademark will be for 10 years, GIS will be for 10 years, and it will be further extendable after the renewal of the fees. And 40 years is not for any other IP product will be given 40 years. So 40 years is a totally wrong for that. So for this patent will be given for a 20 years validity for the registration. So if you write an original story, what type of intellectual property gives you the right of to decide who can make and sell copies of your product? So what it will be? Copyright, geographical indication, patent, designs, trademarks.
Copyright.
Copyright.
Yes, yes, it will be a copyright. So this was my PPT presentation for the today's awareness program, and I feel it is helpful for the all students who will be trying to choose IP field, and I feel I have tried to give my best for the understanding of the intellectual property particular category wise for that trademark, patent, designs, and that semiconductor that is layout design. So if anyone has a doubt, they may ask me questions further for their doubts. I will try to sort out their problems.
So the session is open for discussion. So dear participants, if you have any queries, please feel free to ask. Okay, I think no queries means all participants have understand all the things what you explained, ma'am. So thank you very much, ma'am.
And still, if suppose somebody is not have that to ask now, then if suppose after that also, if you have the questions and if you want any clarification, you may contact our registry, or if suppose it is possible to come down to the Mumbai registry, then I will be there. So I will be trying to sort out your whatever doubts will be there regarding filing of trademarks or GI. So I will be there available for you. Or otherwise, you may put an email to me also. My email ID is available on our official website. So if anyone want to drop an email for queries, they can drop me an email. Yes, please.
How much time is required to in between filing of patent and publication of the patent or acceptance of the patents generally?
Sir, that will not be that the particular time period is not there, because see, when you are filing our that application for your invention, so that will be coming to us, and then you have to file again one more application is there, because there are stages are there and some particular forms are there.
Yes.
That statement of case you have to file, then again examination stages also there. For that also I feel that a particular form you have to file, then only your application move further for the examination. Then examination person will be going through your statement of case and application, and if suppose he has any discrepancy or objections, he will be communicating you, and then only you have to, if suppose modification if you want in your statement of case, or any particular that the process you have mentioned for your invention, so it is not clear, so he will be suggesting you, and then that will be modified by you, and then further if that particular amendment has been done, then only your application will move further. So there will not be any particular time period we can say for grant of patent, and once it is granting, then it will be valid for 20 years.
Next 20 years. Yes. Fast track publications is also there, no?
Sorry, your voice in between was breaking. Fast track you have asked.
Fast track.
You have to pay more for that. Fast track in the sense,
yes, yes.
You will be moved further. Means if suppose your application is on 100 number, so if you are coming for that fast track one, then you will be coming front. Means it will be given priority for that process. It will be. So it is given for trademarks also expedite fees. If you are paying, then your application will be put for that particular stage on priority basis.
Okay, thank you very much, ma'am, for nice lecture. So you explained all the concepts regarding patents, trademarks, copyrights, so all intellectual properties very nicely. So I hope all the participants now aware about all the things, how we can apply for patents, and for which intellectual property we can apply. Or for whether it is for designs or music or anything else, where to apply for the intellectual property. So thank you very much for giving your valuable time to us. So now I request Dr. Naikwade sir to propose the vote of thanks.
Thank you, Chavan sir, for organization of such a great event. First of all, I would like to thank Joint Director of Panvel Region, Dr. Sanjay Jagtap sir, for initiating such type of IPR awareness program. I would also like to thank our principal, Dr. Narendra Tendulkar sir, for giving interest for organization of this program, as well as for the guidance in the organization of this program. Then I would also like to thank Satish Paul sir, as well as Kuldeep Jangir sir, as well as Great Research Committee for organization of this program. Then last but not least, I would also like to thank all my colleagues, as well as all dear students who have participated in this program. Thank you one and all. Yeah, another request to all the participants it is that the feedback link is already shared to you in the chat box. So first you have to fill all the information very neatly, cleanly. So therefore you can get the certificate, e-certificate of this program. Thank you.
Okay. Thank
Okay,
you.
madam.
For the today's webinar, and thank you all of you for listening my PPT presentation throughout 1.5 hours, more than that. So I feel that it is